Now that we have this ruling from the Second Circuit and an earlier ruling from the Fourth Circuit, I think that many of the public officials who have adopted this practice of blocking critics from their social media accounts, but I think now that we've got these rulings, a lot of them are going to reconsider their policies.
There are still some people that the president and his lawyers have not yet unblocked, and certainly this decision is another really strong support for our position that the president just shouldn't be in the business of blocking people because of their viewpoints.
We want to make sure that the conversations that take place in these online forums aren't cleansed of critics or aren't turned into echo chambers by public officials who would, if they had their way, silence their critics.
The next place that they would appeal would be the Supreme Court, and that is up to the Department of Justice and the Solicitor General whether they would appeal this to the Supreme Court. If they did appeal it, although the Supreme Court does not grant review in the vast majority of cases that are appealed to it, there's a high likelihood that the Supreme Court would weigh in on it, but that's right now in the government's decision to make.
President Trump himself has 50 or 60 million followers at this point. Each one of his tweets gets thousands of responses. The comment threads are really where democratic debate takes place. And it's not just President Trump. Public officials all over the country use social media now as their main means of communicating with their constituents. And it's been gratifying to see the way that it's playing out now, both that the courts are accepting our arguments, but also that other public officials are reacting to these cases.